All right, welcome back to the Judicial Proceedings Committee. Good afternoon, everyone. Today is Tuesday, March 25th, 2025. We have 22 bills on the docket. We see that Delegate Ericon is here, so we're going to start off with House Bill 1350. Welcome.
Hey y'all, I'm so tickled to be here. This is going to be super brief. As you guys already know, there's no opposition to this bill. I consider this bill a small tweak, really. I don't think that the body's intended not to include this when we reworked some of our criminal penalties. Basically what the bill does is for fourth-degree sex offense, when you're a person in a position of authority, this would allow for us during the sentencing portion to include the fact that you had previously been convicted of a similar or the same penalty in other states. So right now, if you committed this crime in another jurisdiction, we could introduce that evidence during the sentencing portion to make sure that you got the enhanced penalties that we think are appropriate for someone who is a repeat offender of this type of sexual abuse. This would allow us to do the same thing for those who have committed the same crime outside of our state. That's all the bill does. It was not opposed on our side. It passed unanimously, and it's got a lot of bipartisan support.
All right, thank you very much, Delegate. Questions from the committee? All right, seeing none, thank you.
God bless you guys. Thank you.
All right, with that will conclude the hearing for House Bill 1350. We'll now move on. I think Delegate Cardin is here with House Bill 260.
Thank you, Mr. Chair, members of the committee. It's a pleasure to be over here finally, Mr. Vice Chair. House Bill 260 is a bill that has been put in now a number of years. It has passed a number of years, and we are looking hopefully for a favorable report as well here in the Senate. It was not cross-filed. I guess that's why I'm here this year. I'm not sure why it wasn't, maybe late filed. All this bill does is when we passed the Justice Reinvestment Act years ago, we lowered the penalties for possession of CDS from 4 years to 1 year. Possession of CDS. We neglected to lower the penalties for the adjoining paraphernalia associated with CDS. So now you can be incarcerated for up to 4 years for having a syringe or a spoon or a weight, but you can only be incarcerated for up to 1 year for the actual underlying drug itself. And so what this bill does is it doesn't decriminalize, it doesn't make it legal. All it does is say that the penalties, the maximum penalties, are the same for the CDS and for the underlying paraphernalia, or for the paraphernalia and the underlying CDS as well. It just makes them commensurate. That's all the bill does. There was a slight amendment that you have to make sure that the States Attorneys Association was okay with the legislation, and we took out basically we put back in the possession to make sure that it was clear that it's still illegal to possess, but the penalties are reduced. That's all the bill does.
Excellent. Thank you very much. Senator West.
Thank you, Delegate, for bringing this bill.
Yep.
I note the bill was not uncontroversial in the House.
It was not
34 votes were against the bill. Can you explain where the opposition came from? Were there any responsible organizations opposed? Or
so there was bipartisan. I don't think it was unanimous, but there's bipartisan support in the committee. The opposition comes from the idea that we are, so there's two issues. Number one is that there's a concept that we're decriminalizing it, and we're not. All we're doing is making commensurate with the underlying drug. So that's one misunderstanding I think that drove, as well as the fact that there is some belief that you should have higher penalties for this kind of activity. And if I had my druthers, I would say that we shouldn't be looking at paraphernalia at all. It shouldn't be a criminal act. That's me personally. This was to just focus on the fact that we have an inconsistency in the law, and we wanted to make it consistent.
So to reiterate, what this bill does is makes the possession of paraphernalia, the penalty, identical to the penalty for having possession of the drug that the paraphernalia is used in connection with.
That is correct. And in fact, you'll note that for the most part, this paraphernalia is generally used for either marijuana, weights for marijuana, or syringes for heroin. Heroin is really not a drug of choice these days. There's not many syringes. You can have syringes for many other reasons, for legitimate health concerns. But if you happen to possess syringes, you could be in violation, and you, if, I don't want to get into the specifics on all this because I don't want to start a whole conversation about this, but you could have spoons or syringes for various and sundry reasons having nothing to do with illicit drugs. So in my opinion, we should not be dealing with that. We should be dealing with the underlying CDS. That's fine, but not with the paraphernalia.
Okay, thank you, thank you.
You're definitely from District 11 because Senator Zorkin used to say various and sundry all the time. So.
Really?
Yeah. All right, Senator Fulton.
Thank you. So thank you for the bill, Delegate. So I hear what you're saying, but I still have some concerns because you're bringing up like spoons and needles and, you know, there's got to be some type of burnt residue. There's got to be some type of other factors surrounding it. You're not going to just start locking people up for having a needle.
Generally speaking.
Because my son's a type 1 diabetic.
Right. That is correct. And the state's attorneys may be better to answer these questions than I am.
Yeah.
But yes, there has to be underlying reasons for the original arrest and then for the trial.
Right.
And you're not going to try somebody probably on just the paraphernalia. The problem is what happens if you have a heroin addict and you try them on possession, and then you can get them. You have a rogue state's attorney who wants to put this person in jail for more than a year. Should you be able to? It's a policy question. I don't think you should. That's my opinion, but that's the. Well,
and we'll also have to agree to disagree that heroin's not a problem because it is a problem, and we're losing people every day.
I'm not.
Because it's laced with fentanyl.
Right. So the fentanyl is the issue. How
is it administered into the body?
Well, there's lots of ways to administer it, but yes, I agree with you. But I'm saying that heroin is not it's not the primary. So it's the fentanyl, and you're correct.
I just don't want to make sure we're not minimizing things here.
There's less paraphernalia that's associated just with fentanyl than it is with the heroin.
And you said there was no cross file, but I see a cross file. So is that wrong?
I don't believe that maybe the cross file didn't go anywhere, which is why I'm here.
You had
it's
the same cross file that might not be here right now, but I'm just saying. 1009. Okay.
Maybe it was late. It sounds like that was a late file.
Oh, it's in rules? Oh, it was late file. Okay.
Late file.
All right. Thank you.
I have your amendment also drafted on the other matters. So we'll take care of that.
Yeah, we need to talk about that too, but anyways, thank you.
All right. Thank you very much, Delegate. Seeing no further questions, that'll conclude the hearing for House Bill 260. I see Delegate Tricutian is here, so we're going to go with House Bill 1032.
Thank you, Mr. Chair, Mr. Vice Chair, colleagues. Good to see you. For the record, House Delegate Lori Tricutian asking for a favorable report on House Bill 1032. I'm actually here on behalf of the Montgomery County delegation. This is sort of an unusual bill in that we've got combined a couple of delegation bills. But I'll just create the context. This bill basically expands. Last year, the General Assembly authorized a pilot project in Prince George's County to test and monitor for 5 years the use of stop sign monitoring cameras. So in school zones, the idea being that a huge number of pedestrian fatalities occur at stop sign intersections, as well as other accidents involving vehicles occurring at stop sign intersections. Priority, when we're looking at all of the walkability issues, is school zones. And so last year, the legislature decided to move forward with a pilot that would allow for stop sign cameras in school zones in Prince George's County. Since then, both Montgomery County and Baltimore City have been exploring those options. Both the Baltimore City and Montgomery County House delegations wanted to move forward with the ability to pilot for the next 5 years stop sign cameras in their jurisdictions. So that's the bill sort of as it left the House. The Environment and Transportation Committee combined both of those bills into one bill. And so what you have in front of you in 1032 is a desire for, represents the desire of both the Montgomery County and the Baltimore City House delegations to be able to pilot stop sign cameras. So that's just kind of why it's combined this way. I'll just say a few things about concerns about pedestrian safety, which I think that this committee is probably fairly familiar with. And I think that I know that there's still processes going on with the various Senate delegations of Montgomery County and Baltimore City in determining how they want to move this forward. So what I'd like to do, if it's okay, is sort of answer questions about the broader bill as it stands, and I think then you're probably expecting letters from those delegations in terms of whether they support the bill in general or if there's subsets of their counties that they're going to request that the body move forward with.
Hi, Delegate. Thank you for the bill. Okay, I think I just found it. I was looking for the,
1032, yeah.
yeah, well, I was looking for the fee, the penalty.
$40? Mm-hmm. Yeah.
Okay, thank you.
Mm-hmm. Yeah, so the fees don't change from other sort of camera fees. Yeah. Yes, yeah. Okay.
Thank you, Mr. Chair. Do we have the letters yet from Montgomery County and Baltimore City?
So the Montgomery County and Baltimore City House delegations were in unanimous support. That's kind of how it came from the House. It's my understanding that the Montgomery County delegation, Senate delegation, has not yet voted in the Senate.
How about Baltimore City?
And I think Baltimore City, I'm hesitant, sorry, my hesitation on this is I don't want to try to speak for Baltimore City. I don't know if.
Unfortunately, we don't have any senators on this committee for Baltimore City.
It's my understanding that they may be asking for this to move forward for just one district in Baltimore City.
Oh, okay. So we'll have to wait a little bit and see.
Montgomery County meets Thursday, and I think, do you have a Baltimore City letter yet? Okay. That's what I heard was happening, but I'm trying to be careful not to speak for them because.
Thank you very much.
Not them.
All right. Any further questions? All right, seeing no further questions, thank you very much, Delegate.
Thank you.
All right, with that, that'll end the hearing for House Bill 1033. I saw Delegate Solomon is here. Hey, welcome.
Mr. Chair, if it's okay, there's two folks here from Montgomery County just for questions.
Excellent, yeah.
You guys want to come up?
Which bill are you,
1173.
excellent, House Bill 1173.
Thank you, Mr. Chair. It's nice to see many of you. For the record, Delegate Jared Solomon here to present House Bill 1173 on behalf of the Montgomery County delegation. And this bill has been voted unanimously out of both delegations, both the House and the Senate. I hope you have the letter. And then it was moved not unanimously, but overwhelmingly out of the House. This is a bill actually that you all considered last year. What this would essentially do is allow for Montgomery County to, and I will take a step back, this is a priority for both our Department of Transportation as well as the Montgomery County Police Department. And what this bill would essentially allow is for Montgomery County to place cameras on their high injury network corridor of roads. And current Senator Love was a wonderful partner on this when she was in the House on the Environment and Transportation Committee. We looked for a way to make sure that Montgomery County was able to essentially put cameras in the most at-risk, unsafe locations throughout the county. So the HIN, the high injury network roadways, make up only about 3% of the total roadways in the county, but it's where 40% of the fatal or serious crashes occur. And so we went this route instead of trying to widely broaden the overall categories of roadways in which the county could put it on. We've worked in collaboration with the State Highway Administration over the last year or two. Montgomery County does a very thorough analysis of their roadways regularly. They have incredible data to show how the camera program has made our roads significantly safer. This bill was almost identical to the bill that you all considered last year. Again, unanimous out of both the House and the Senate delegation. The only changes were we just clarified a little bit of the language to make sure there was no ambiguity, because we do have two municipalities in Montgomery County, Rockville and Gaithersburg, that have their own camera program, and we wanted to make sure that they would be able to take full advantage of this. So we tweaked the language to clarify that if they don't have, if they call their roadway safety plan something slightly different, then as long as the intent of that plan is the same, it's allowable for the State Highway Administration. And then we also clarified that similar to the way the county does it, any revenue above and beyond the cost of the program goes back into the transportation program for roadway safety, that same rule would apply for the two municipalities as well. So with that, I would urge a favorable report and happy to take any questions.
Mr. Chair, do we have a letter from the Senate?
You should. I do not have access, unfortunately, to the Senate floor system, but I know it was passed unanimously out of both delegations. So,
okay. So we had a bill earlier today which suggested that we should accord to the State Highway Administration pretty much carte blanche to put speed cameras on state roads, state highways. They're the same definition, 2 lanes, 4 lanes, whatever, wherever they want, so long as they qualified under the state definition of this, like high impact roads or something along those lines. So this is a similar bill that then the state bill would have been statewide. This is county-wide, but it's the same idea. So we're basically giving up our authority in the future to make decisions on where the speed cameras go. I'm not necessarily opposed to that, but I do think that there ought to be some parameters put around what Montgomery County could do. For example, it would be imprudent, I think, for Montgomery County to charge $500 a fine or to charge fines for speeds 1 mile over the speed limit. I'm wondering whether your bill has any sort of conditions like that in the bill which would govern future decisions.
yeah, Senator, I really appreciate the question, and I know we've got the administrator of our Vision Zero program here as well, and Chris Hippery, who's from our police department, who runs our automated enforcement program, unfortunately couldn't be here. So to answer a couple of parts of your question, so this is broadening the allowable locations of cameras, but still within the confines of the current law. So it would be for 12 miles over the speed limit. It's the same fee structure that is in place for current cameras. The only thing that this does is gives Montgomery County the ability to potentially put these cameras at additional locations. If it was a county road, then obviously the county can sort of do things on their own. If the county chooses to place a speed camera on a state road, they still have to go through the same process that they would today, where they have to get a permit, they have to work in concert with the State Highway Administration, who I will say has been a really wonderful partner. We have some of the most unsafe roadways, frankly, in the county, in our district, and the State Highway Administration is a really good partner. The one thing I will say, I think, to the bill that you mentioned before, I'm not going to get into the merits of that bill, but the one drawback, and I know the folks from the county feel this way as well, is that if we were to put that one forward, the state is not ready tomorrow. The state could not do a program. They would have to essentially start procuring cameras. They would have to set up an entire structure. Montgomery County, I believe, is maybe the first jurisdiction in the state that's done a camera program. So we have one of the longest running ones. It's sort of one of the best established, certainly in the state. They've won awards actually in the country for administering it. So this would allow the county to go sort of immediately forward on this. And again, it is not everywhere. It is, they do a safety plan, every 5 years that identifies the most at-risk, unsafe corridors in the county. And that list is where these cameras can be placed. And that list is in conjunction working with the State Highway Administration that gets reviewed annually. So this does not give them carte blanche to put them anywhere. I think it's about 80 locations, give or take.
60 miles of road.
60 miles of road in the county.
Okay. Thank you very much.
Thank you, Mr. Chair. Thank you for bringing the bill. So if I'm hearing you correctly, I'm hearing you say that Montgomery County already has a plethora of cameras at their disposal to start installing immediately.
So I will defer to Wade. So I know the county has certainly a robust contracted program that would allow the county to make the decision, if again, permitted by the State Highway Administration, to place them on state roads, or obviously, they control their own county roads.
Yeah, they've got a robust camera system down there. Brings in a lot of money.
I will say, actually, the camera program, and the county folks can speak more to this, does not make money. And whatever extra money there is goes immediately back into road safety, and we have a backlog of 2 or 3.
I would love to see that, exactly that thing. I'd like to see where that money's going, because I don't believe that's, I'm not sure that that's completely accurate. I hope it is. So I'm sorry, I thought he was going to answer, but
Yeah, if you want to come up.
can that be provided, that detail that he just said?
Or do you want to stand?
Yeah, so every year we're required by state law to do a report on net revenues. So the last 2 reports we provided to the state show that we actually did not make money on the speed camera program. There is net revenue positive on speed, red light, and bus combined. It's around $8 to $9 million, but for the speed cameras themselves, we did not make any net revenue last 2 fiscal years.
Can you explain to me how Montgomery County, with all their speed cameras that they have and the amount that they bring in, is making no money on this? Are you telling me that the vendor's making all the money?
So the vendor, yes, after we pay the vendor, we have our own staff costs and.
So how much last
expansions.
year did you all bring in on speed camera bills?
I don't have the exact number for me, but I can go back and grab the report, but the overall, the annual report that we submitted showed like negligible to 0 net revenue after paying for everything.
Yeah, I'd love to see those numbers if you can get those, because I'm now mind blown by the number of speed camera tickets that Montgomery, or speed camera locations that Montgomery has, is that you're telling me that it's basically a net 0 effort that goes back into the safety of the community. But it would seem that if you're a speed camera vendor in Montgomery County, you're doing quite well, because they're getting a lot of money. So I'm asking now, what's the overall net benefit to the community?
Yeah, so the vendors are paid, especially for speed camera by state law, they're only paid by fixed fee. So if they have 1 speeding ticket or 1,000 speeding tickets, we pay the same fee for those cameras. So they don't make more money or less money based on
Okay.
how many citations are issued.
Okay, yeah, if you can get me that, I'd appreciate it.
Absolutely.
And then Delegate, you brought up about the fee, I guess, that it was going to be consistent with some, like the other speed camera locations.
I was going to say, nothing in our bill affects the fees. It's just literally giving them access to these specified group of locations. We don't tweak the fee at all. Whatever's in the bill, it's current law.
So I guess my question is, Mr. Chair, is this going to change off of the language of the other bills that we have, where we're moving or is it going to have to be added into this? Okay. Because this is under 21,809? Correct. So this would be a part of the fee increase across the board? Yes. And are you familiar that bill's out there?
I am. I mean, that's.
Well, there's one way to make a net profit benefit to the county. All right, thank you.
I will say, Senator, I mean, I'll take Connecticut Avenue as one of the examples. We've had several fatalities, as the vice chair knows, and our delegation, our district, has worked long and hard on improving the safety. There are a number of speed cameras, and we have not had serious accidents on that road. I mean, again, working in concert with the State Highway Administration, it has made a tremendous difference. That's a road I live off of. My kids go to school near there, so we're not out to make money. We're out to make our roads safer. And in our little neck of the woods, it's made a difference.
All right, excellent. Thank you very much. Seeing no further questions, that'll end the hearing for House Bill 1173. Thank you very much, Delegate.
Thank you.
Thanks. I'm told that is Chair Wilson here? Okay. Well, the actual chair. All right, let's do. Is Chair Wilson here? Or you're.
No, sir. Yeah, I'm his legislative director.
Okay.
I'm all set, Chairman. Okay, good afternoon, Chairman Smith, Vice Chair Wallstriker, and members of the esteemed Judicial Proceedings Committee. For the record, my name is Sharon Lanier. I serve as Legislative Director for Chairman C.T. Wilson, and I'm here I stand before you today in strong support of HB 5, a critical bill that expands the definition of child sexual abuse material in Maryland law to include computer-generated images created using artificial intelligence software. This, of course, AI technology is a rapidly advancing, and while it may have, beneficial applications, it is also being used to create realistic and misused to create realistic AI-generated child sexual abuse material. Even though these images may not depict actual children, they fuel demand for exploitative content, encouraging predatory behavior, and can re-traumatize survivors by using their likeness and manipulated imagery. Maryland's current criminal laws do not explicitly cover AI-generated abuse material, allowing offenders to escape accountability under these technicalities, and this bill ensures our laws evolve alongside technology. This bill looks to be a proactive approach in closing a dangerous loophole before it can be exploited further, reinforcing Maryland's leadership in child protection, as well as criminalizing the creation and the distribution of AI-generated abuse content. We cut off demand and send a clear message that Maryland will not tolerate any form of child exploitation. Simply put, HB 5 is about more than updating our laws, but more so reaffirming our commitment to protecting Maryland's children in every space, including the digital world. By passing this bill, we ensure that no loophole allows offenders to hide behind technology and that Maryland continues to lead in child protection. Request a favorable report. Thank you kindly.
Thank you so much. You did a fantastic job. Questions for the sponsor's staff member? All right, seeing no questions, thank you so much for your testimony. We'll now move on to Delegate Ahrens. Come on up.
Ready? Okay. Good afternoon, Mr. Vice Chair and members of the committee. For the record, Steve Ahrens, I'm here to present House Bill 1236, Queen Anne's County Municipality Speed Limits. This bill will allow Queen Anne's County to decrease the maximum speed limit to not less than 15 miles per hour on a highway without performing an engineering and traffic investigation. The town of Queenstown has requested this legislation in order to enhance public safety and to reflect their unique needs in the town, reducing the risk of accidents and create a safer environment for all residents. If you're familiar with Queen Anne's County, Route 18 kind of winds through our little towns and municipalities, and that's the purpose of the bill. I have support letters from my delegation in the House, the Senate delegation of one, Queen Anne's County, and also Queenstown. I urge a favorable recommendation on the bill.
Thank you.
It's passed unanimously in the House too, I'm sorry, in T&T. Thank you.
Wonderful. Thank you. Questions for Delegate Ahrens? All right, seeing no questions, thank you so much for joining us here today.
Thank you very much.
The next person I saw in the audience was Delegate Bandari. Delegate Bandari, you, okay. He stepped out while we're waiting for Delegate Bandari. Delegate Simpson, if you want to fill in, please, whenever you're ready.
Good afternoon, Chair, Vice Chair, and members of the committee. My name is Jocelyn Alasko, Delegate Simpson's Chief of Staff, and I'm here to present HB 492, which authorizes Frederick County to perform fingerprinted assisted background checks. Streamlining background checks is a county priority supported by the Frederick County Delegation and the Frederick County Sheriff. This bill's cross-file, SB 995, is currently in Senate rules. Delegate Simpson would like to thank Senator Muse, Senator Sidnor, Senator West, Senator James, and Senator Folden for cross-filing important bills that focus on matters such as the suspension of driver's licenses, HB 110, and intercepted communications, HB 130. Delegate Simpson appreciates the committee's time and dedication, and we ask for a favorable report of HB 492. Thank you all so much. Happy to take any questions or concerns.
Any questions today? Very well done. Anything to,
Vice Chair Delegation.
anything to add, Delegate Simpson? We're good?
Yeah.
Wonderful. Good
Other
stuff.
than
Thank you so much. I appreciate your being here today. That concludes the hearing for that bill. We'll now move, I think Delegate Bandari did return. Come on up, Delegate Bandari.
Thank you.
Thank you.
Thank you, Mr. Chair, Vice Chair, and members of this wonderful committee. For the record, Delegate Bandari testifying on House Bill 1544, Public Safety Maryland Law Enforcement Public Service Medal and Key Breeze Collapse Victim Memorial Tribute. On March 26, 2024, the tragic collapse of the Francis Scott Key Bridge claimed 6 hardworking lives, and in that moment, our emergency response teams were tested like never before. These individuals were working through the night to ensure our safety. Were not just workers, they were parents, siblings, and friends, all of whom had dream and aspiration that were their life were cut short. In addition, we honored the officer who showed extraordinary courage that night. The Key Bridge became more than just a structure. It became a symbol of resilience and the strength of our community. Law enforcement officers risked their lives to save others, and their swift actions prevented further tragedy. The inspiration for this bell came from a deeply moving experience at Casa, Baltimore, where I stood alongside grieving families and witnessed the powerful display of helmets, each one representing a life lost. That moment underscored the need for us to take meaningful actions to honor their sacrifices. Additionally, I, along with other delegates from Health and Government Operations Committee, have worked together on amendments to expand the scope of the bill. The changes will not only recognize these workers, law enforcement officers, but will also include highway workers and pilots who played vital roles in the recovery efforts following the Key Bridge collapse. New medals will honor these individuals for their bravery and dedication during this critical time. And I took the amendment from the Maryland Law Enforcement Public Service, the Maryland Chief of Police Association, MCPA, and the Maryland Sheriff Association, who support this HB 1544. Beyond honoring those we lost, this bill is a testament to the selflessness and courage of all public servants as we rebuild our bridge and infrastructure. Let this bill stand as a symbol of our collective gratitude. I urge a favorable report on HB 1544 because this is the right thing to do. If you have any question, I'm here to answer.
Wonderful. Thank you for bringing this bill. Questions for Delegate Bhandari? All right, thank you, Delegate Bhandari. That concludes the hearing for House Bill 1544.
Thank you.
Thank you. Has Delegate Schindler joined us? Delegate Schindler, you are up. Welcome to Judicial Proceedings with House Bill 748.
Mr. Chair, Mr. Vice Chair, honorable members of the committee, for the record, I'm Delegate Matthew Schindler, and I'm here to testify in strong support of House Bill 748. House Bill 748 is an enabling legislation, simply allowing municipalities to authorize code enforcement officers to wear body cameras if they so choose. This legislation would allow municipalities to enhance transparency and ensure that enforcement officers and constituents are able to access a record of their encounters. In my previous experience as a member of the Hagerstown City Council, I witnessed many complaints or issues regarding our code enforcement that could have been readily resolved if there was a digital record of the enforcement encounter. I believe this legislation will create a tool that can boost government trust, efficiency, and transparency. Body-worn cameras also act as a deterrent towards potential aggressive or confrontational interactions, providing safety for both our officers and citizens. This bill carries no fiscal note and merely gives local jurisdictions another tool in their toolkit. With that, I thank you all for your time and respectfully urge the committee for a favorable report on HB 748.
Thank you, Delegate. I remember my first time in JPR. I didn't understand why I had to stand instead of sit at a table. I didn't understand why there were so few people in the room. I'll address that in a second after this bill hearing. So it's not an easy thing to do, so we appreciate your being here.
Thank you for having me.
All right, so that concludes the hearing for House Bill 748. I saw that Delegate Bartlett was here earlier. Is she out in the antechamber? Okay, thank you. While we're looking to see if Delegate Bartlett is in the antechamber, I would just note for our audience here in person and at home, the House committees are similarly meeting, and our senators are over in the House presenting their bills, just as delegates are here presenting theirs. And so if you're wondering where our senators are, they are in the House doing the people's work. As we wait for Delegate Bartlett, there's a series of local bills on our agenda today. Local bills are not listed by which delegate is presenting them, so I don't know who is here to present those bills, and so I'm just going to go through them here, and if a staff member or a delegate is here to present that bill, just please come on up. Is anyone here for House Bill 371, Prince George's County Delegation, Speed Monitoring System, Maryland Route 5 PG 308?
Right here.
Please come on up and present the bill.
Good afternoon, Mr. Chair. For the record, my name is Cameron Gross, Legislative Director for Delegate Jeff Long, who couldn't be here today due to the passing of his grandfather. Thank you for the opportunity to present House Bill 371, Prince George's County Speed Monitoring Systems on Maryland Route 5. For years, Maryland Route 5 has been a dangerous corridor with a long history of excessive speeding, reckless driving, and most tragically, preventable accidents. This stretch of road has seen far too many crashes, resulting in injuries, fatalities, and devastation for families in our communities. The data is precise. The speed is leading to factors in these incidents, and the time to act is now. The support for this legislation is overwhelming. Constituents from across Prince George's portion of District 27B have made their voices heard, calling for action to improve safety on Route 5. They have witnessed firsthand the dangers posed by speeding vehicles, whether drivers or residents living near the high-traffic corridor. Local leaders and concerned citizens have all echoed the same message: we need solutions. Speed monitoring systems are a proven tool in reducing speeding and preventing crashes. Similar programs in other jurisdictions have led to measurable declines in traffic violations, safer roadways, and most importantly, fewer injuries and fatalities. We cannot afford to wait for another tragedy on Maryland Route 5. House Bill 371 is a common sense approach to making Maryland Route 5 safer for everyone who travels it. With that, I urge a favorable report on House Bill 371. Thank you.
Thank you so much. Questions for this sponsor? If not, thank you. That concludes the hearing for House Bill 371. Wait 1 second. I see Delegate Bartlett has joined us, but I do have a House Bill 408, Prince George's County Delegation. Are you presenting that? No. Okay. If it's not the same person, then let's go to the delegate, Delegate Bartlett. And this bill is not sponsor only, so we have a couple witnesses. Delegate Bartlett, please, whenever you're ready.
Thank you. I'm not a witness, but I am going to wait for information.
Yeah.
Thanks for sticking around. Okay, thank you. Thank you to Vice Chair Wallstreicher and to the committee. Thanks for indulging. So I'm here and very happy to present House Bill 1123, Sandy Bartlett, District 32, Anne Arundel County, for the record. So what is the problem that this bill addresses? With this bill, we seek to reform medical and elder parole in Maryland because our DPSCS facilities are not equipped and personnel are not trained to provide necessary medical care for older incarcerated individuals. Testimony in the House and supported in a guest commentary article by Justice Policy Institute entitled "Maryland Must Embrace Compassionate Release for Aging and Sick Prisoners," dated February 6, 2025, was that there are inmates who are providing medical care for aging and ill inmates, and that according to their analysis, JPI's, Maryland spends tens of thousands of dollars annually per aging prisoner on health care costs alone. From my personal visits to facilities, I also know sometimes when an inmate has severe dementia, they are placed in restrictive housing for most of the day and night. Further, we have a serious problem involving a wait time for medical parole review, and people are just not being released under geriatric parole. This bill is a first step attempt to reform parole by starting with medical and elder parole. This bill recognizes that sick and older adults differ from our younger offenders in terms of rehabilitation and risk, and therefore should be evaluated through a lens that accounts for their unique circumstances. You may recall there was a hearing on Senate Bill 181 which this body voted out favorable with amendment and passed out of the Senate. House Bill 1123 is very similar to the amended Senate Bill 181, and I'm working with the Senate sponsor to put both bills in the same posture. You do not have the amendments that in front of you today because we are still in negotiation. And I will quickly talk about what we agree on, and then I'll go over where we disagree. With respect to medical parole under Section 7-309, first, each bill, meaning House Bill 181 and 1123, removes the governor from the medical parole process, acting as a technical fix to the 2021 legislation. Each bill also only applies to individuals who are parole eligible because they were sentenced with the possibility of parole. Second, both bills create new eligibility criteria for medical parole consideration. Each defines chronically debilitated or incapacitated and terminal illness and the included conditions that fall within those terms without any differences between the bills. A technical fix differs between the bills on medical parole, and we agree on that fix. We agree that a parolee may be returned to custody if a licensed medical physician makes the determination that the individual no longer meets the criteria of medical parole and is not a danger to public safety. That can be found on page 8 of Senate Bill 181. Lastly, with respect to medical parole, we agree that the Commission shall adopt regulations to implement the changes to medical parole. Now, this is where we disagree. Geriatric and elder parole under Section 7-310. We disagree, but not widely. For instance, we, the Senate and House sponsors and advocates in support and opposition, have held meetings to come closer to a full agreement. We are not there yet, but we are very close. By amendments, we address many of the concerns in the opposition and those who are favorable with amendments. We agree to raise the qualifying age to at least 65 years old for inmates who have served a continuous 20 years of their sentence, but has not had a 1A disciplinary infraction within the past 3 years because, yes, no major infraction is vague. We also agree that anyone who qualifies for the sex offender registry does not qualify for geriatric parole. We agree that a stay-away order should accompany the granting of parole. So this brings us to the issue of who within the qualifying pool of individuals are eligible for geriatric parole and should have a risk assessment. This is where we have not come to an agreement. As written in House Bill 1123, it requires DPSCS to provide a list of qualifying individuals for geriatric parole, and within 60 days of receiving the names, the MPC must conduct a risk assessment for everyone who would potentially be granted geriatric parole. The opponents would prefer that only geriatric individuals who are serving a life sentence receive a risk assessment. They fear that the backlog would not be addressed, and adding more people to the risk assessment requirement would merely increase the backlog. We addressed this issue in House Bill 1123 by authorizing the Justice Reinvestment Oversight Board, JROB, to recommend that a portion of the annual savings from the implementation of the recommendations of the Justice Reinvestment Coordinating Council be distributed to MPC for the purpose of hiring psychologists to perform the recommended risk assessments. Apparently, it is the current uncodified policy that MPC always conduct risk assessments for individuals who have been sentenced to life with the possibility of parole. Thus, I have submitted a proposal to the opposition to codify that language because their concern was that there would be risk assessments conducted for people who are not required to have a risk assessment now. In our last meeting, it seemed that we agreed upon this proposal, but because we are looking at paroling individuals who have been continuously incarcerated for at least 20 years, we also propose that the risk assessment apply to them and anyone who was sentenced to a term of years of over 40 years of active incarceration, and give the MPC the discretion to determine whether to conduct a risk assessment for anyone else who doesn't fall within that criteria. This offer has not yet been accepted, but you see, we are very close, and hopefully we will come to an agreement on the risk assessments. While national studies have found that the reoffense rates for people released at age 60 or older are quite low, the studies have not shown that the reoffense rate of these individuals is 0. Therefore, this bill, as amended, not only strikes the balance, but also alleviates some of the financial cost that medical and elder populations of incarcerated individuals place on our systems. It is critical to prioritize public safety while also ensuring a balance with the broader interests of our criminal justice system. Ultimately, with House Bill 1123 as amended, we aim to promote fairness, efficiency, and compassion. Thank you for your consideration. Thank you for letting me go this long with this, but I wanted to make sure we got a chance to talk about where we are, and a favorable report is requested. Thank you very much, Mr. Chair.
Thank you, Madam Vice Chair. We appreciate the transparency and the hard work and persistence you've put into this. I like a good pre-conference, and that's what's happening here. So let's do this. If you need to return to your committee, we can take questions for the sponsor and then take further questions after the panel. If you if you wish to stay, we'll take questions just after your panel, whatever your preference.
Well, my chair knows where I am.
Okay.
So I know he's going to be at the helm for a little bit, and he won't need me just yet. So I'm going to go ahead and stay.
Well, perfect. Our tradition is to take the full panel. Ms. Meadows.
Good evening. My name is Lila Meadows. I'm an assistant public defender with the Decarceration Initiative with the Maryland Office of the Public Defender, and we're here to urge a favorable report with amendment on House Bill 1123. I first want to thank the committee for issuing a favorable report on Senate Bill 181 that deals with the same issues, medical and geriatric parole. As Vice Chair Bartlett testified, the medical parole language in these two bills is substantively the same. We are truly in agreement with that language, and where we differ, as the Vice Chair testified, is with respect to geriatric parole. I will be brief. I know it has been a long day, and so I will just say that we are asking for amendments that do define what a major disciplinary infraction is. As you can imagine, that different parole commissioners might interpret that differently, and that would lead to disparate outcomes. And I think we are in agreement on that clarifying language. And so the status is exactly what Vice Chair Bartlett said. We continue to be in conversation with the Vice Chair, look forward to that. The Maryland Office of the Public Defender has not had an opportunity today to confer with our Senate sponsor, but look forward to doing so to try to reach an agreement with respect to the risk assessment. Thank you.
Great. Madam Director, I don't have you signed up to testify, but if you have.
So I was not picked to testify, but because justice reinvestment in that fund comes out of GOCAP, I'm really here to answer any questions. The plan is that we would grant money to the Parole Commission to hire additional risk assessors. Right now, there's only one person doing risk assessments. There's a backlog of 150 people. And under House Bill 1123, under that criteria, there were 67 people who were eligible. 55 of those require a risk assessment no matter what, and the other, it depends on which version of the bill gets passed. So in order to clear out that backlog, we were going to provide the money. And I can answer questions, but thank you.
Thank you so much. Questions for the sponsor or her panel? All right, seeing no questions, I would just add, I was on the work group on the Senate version, and one of the wonderful and unique things that happened was that the public defenders and the State's Attorneys Association agreed and issued a joint statement indicating their agreement in the Senate version. And so I know you're conferring with the Senate sponsor, and that, of course, is the right thing to do. We want to make sure the Senate sponsor is fully supportive of the final product. But to the extent that we can recreate the original agreement that the State's Attorneys Association and the Public Defender are also in agreement with this final language, I think that would make our jobs easier on this side of the table. So. Thank you all. With that, that concludes the hearing of House Bill 1123.
Thank you. Thank you very much.
Oh, I'm sorry. We do have opposition for that bill. I apologize.
I was going to say.
Yep. So that does not conclude the hearing. We'll go back to this House Bill. State's Attorney Schellenberger.
Good afternoon, good evening, whatever. Scott Schellenberger, State's Attorney for Baltimore County. I wish there were more people here because I could shock everyone. You can see in my written testimony that I attached my agreement with Senate Bill 181. And because of that, I opposed the current bill 1133. But Delegate Bartlett, I'll even shock you more. I heard your amendments, and therefore I think they're okay. And I can, if it makes it look just like the Senate bill, then I can also support this one. The two things that really concerned me was calling someone 60-year-old geriatric. That's bothered me for the last 6 years. And more recently, last year, calling it 65 geriatric is even more concerning. I think we need to take the age up, but I'm sorry, I don't mean to try and be funny. I like Senate Bill 181. If you make 1123 look like 181, then I'm here to say support.
All right. Sounds good. Any questions for the State's Attorney? All right, thank you again. That concludes the hearing for House Bill 1123. We'll now return to some of the local bills. I saw someone was here on House Bill 408 from the Prince George's County Delegation, Coordinated Youth Violence Review and Response Team.
Good afternoon, Mr. Vice Chair and members of the committee. My name is Paul Andrews, and I'm here on behalf of Delegate Julian Ivey to present House Bill 408. This is a local bill which passed out of the Prince George's County House Delegation, as well as the House of Delegates with unanimous support. The bill establishes a Prince George's County Coordinated Youth Violence Review and Response Team, which will be responsible for examining and preventing violence against youth through intensive case management. The Review and Response Team's membership will consist of the County Executive, the Chief of the Prince George's County Police Department, the Prince George's County Health Officer, the Superintendent of Prince George's County Public Schools, the Director of the Department of Security Services for Prince George's County Public Schools, the Director of the Prince George's County Department of Social Services, and the Secretary of Juvenile Services. Any of these aforementioned parties may select a designee in their place. Additionally, there will also be 2 representatives who come from nonprofit organizations which operate within Prince George's County. The Review and Response Team will have a first reporting date of January 1st, 2027. Thank you all for your time today, and we're asking for a favorable report on House Bill 408.
All right, thank you so much. Any questions for the sponsor? All right, thank you so much. I appreciate your being here. Delegate Pasteur, I missed you earlier. I did not see you over there because of my line of sight. My apologies. And so we'll move to House Bill 853, Post-Conviction Review Procedure to Reduce Duration of Sentence. Delegate Pasteur.
Thank you.
And you're welcome to bring your panel up.
Greetings, Vice Chair Waldstreicher and the Judicial Proceedings Committee. For the record, I am Delegate Cheryl Pasteur. I am the delegate from Baltimore County, District 11A, and I'm here regarding House Bill 0853, which in my mind, which is a little different from the testimony I submitted. It is about redemption and growth and now belief and mercy. Isaiah 44:22, return to me, for I have redeemed you. House Bill 853 passed third reader on March 17th, 2025, and is a legislative Black Caucus priority. Second look as amended is built on the Juvenile Restoration Act and the Unger versus Maryland decision. These measures have demonstrated that sentence reconsideration does work. Second look authorizes individuals to petition the courts to reduce the duration of a certain sentence if the individual was convicted between ages 18 and under 25. This individual was not sentenced to life without the possibility of parole, not a sex offender as defined in Section 11701 of the Maryland Criminal Procedure Code, and has served at least 20 years. The individual must have met at least 10 significant criteria, which includes victim or victim representative statements or anything that the judge requests related to readiness for re-entry into society. Second look is not a given. It is not a given for the petitioner, but allows the courts to reassess sentences based on long-term behavior and growth designed to consider public safety and to ensure accountability. The courts may only reduce a sentence if it finds that the individual is not a danger to the public. Second look builds on the recognition that redemption is possible. It is not a partisan issue. It is a moral and economic necessity. It is an opportunity to live up to the values that we profess. Currently, 24 states, red, blue, purple, have enacted second look initiatives in many different ways, with other states watching Maryland. In November, Senator Cory Booker presented the Second Look Act bill in Congress. Maryland has the largest rate of incarceration and incarceration of African Americans of any state in this country. The act creates a legal pathway for reviewing excessive sentences that disproportionately impact Black Marylanders. Why second look and not parole? Around the country, legislators and courts are looking to judicial review as a more effective means for reconsidering a person's fitness to re-enter society. It is an opportunity to evaluate whether sentences imposed decades ago remain just under current sentencing policies and public sentiment. For Maryland, it will break a vicious cycle among our youth and overcrowdedness in prisons. You moved the Senate, and in the Senate, cross-filing last session under Senator Carter, but the House faltered. Your amendments were the model for the amendments in House Bill 853 this session. It is to your light that I return. I am hopeful that you will stand up once more and give House Bill 853 a favorable vote. Thank you.
Thank you for your testimony. As I mentioned earlier to Vice Chair Bartlett, our tradition is to wait till the end of the panel for questions, but if you need to return to the House, we are happy to take questions now, whichever is your preference.
No, I will wait.
Okay.
My chair knows where I am.
Thank you. Okay. Then we will first go to Mr. Sakenti. Sacenti? I apologize if I mispronounced it.
It's Sacenti, and thank you very much, Mr. Vice Chair. Good afternoon. My name is Brian Sacenti. I'm the Director of the Public Defender's Decarceration Initiative. We represent people in motions for sentence reduction under the Juvenile Restoration Act. The Public Defender's Office supports House Bill 853 because it expands the Juvenile Restoration Act's second look mechanism to include people who are emerging adults at the time of the crime. This decision by the House was based on the recognition that the parts of the brain responsible for decision-making, risk assessment, emotional regulation, and impulse control do not fully mature until around age 25. For the reasons set forth in our written testimony, OPD philosophically believes that second look should be available to all, including people with life without parole sentences. But to be clear, we support enthusiastically this bill because it is an important step forward that will give a significant number of people who've turned their lives around an opportunity for sentence review. Opponents list other mechanisms under Maryland law for judicial review and then describe this as a 14th look. That is a great soundbite, but it's misleading. None of them permit a court to decide whether incarceration remains warranted after enough time has passed for the court to assess the person's growth and rehabilitation. Indeed, as to that, what the statute provides really is a first look. I've had the privilege to help clients obtain their freedom based on the Unger case and the Juvenile Restoration Act. The new offense recidivism rate for both groups is very low, in the neighborhood of 3 to 4% range. I've witnessed people who were convicted of terrible crimes when young transform their lives, become forces for good behind bars, and then, if released, continue to become forces for good in their communities. I've also seen amazing moments of grace and forgiveness by victims and their families at some of these hearings. If the committee has any questions about how these proceedings work in practice, I'll be happy to try to answer them and would conclude by respectfully urging the committee to pass this bill. Thank you.
Thank you so much for your testimony. Mr. Melvin, you're up. Go ahead and unmute yourself and you're good to go.
Mr. Chairman and members of the committee, my name is Robert Melvin. I'm the Northeast Region Director at the R Street Institute, a public policy research organization that promotes free markets and limited effective government. We support House Bill 853, the Maryland Second Look Act. Second look laws, when done well, can save taxpayer dollars and better prioritize prison resources without compromising public safety. House Bill 853 allows defendants between the age of 18 and 25 at the time of conviction to request a sentence reduction after serving 20 years, with limitations to prevent frivolous violence. It excludes life without parole in certain sex offenses, which we feel like is noteworthy. This bill establishes a hearing process where factors like age at the time of the offense, rehabilitation efforts, and victim testimony are considered. This ensures that courts review whether continued incarceration was warranted from both safety and economic perspectives. Maryland faces prison overcrowding, correctional officer shortages, and rising incarceration costs. The state spends around $114,000 per prisoner annually, and the population is growing, exacerbating these issues. This measure could help reduce the inmate population, lower costs, and alleviate pressure on Department of Public Safety and Correctional Services. Importantly, second look laws encourage prisoner rehabilitation by offering reconsideration based on progress, reducing the likelihood of reoffending. Research shows that recidivism decreases significantly as inmates age, with those serving long sentences rarely returning to crime. Many states, as you have heard, have successfully enacted similar laws. This measure balances public safety and fiscal responsibility while addressing prison growth and the high costs without compromising safety. We urge a favorable report on House Bill 853. Thank you.
Thank you, Mr. Melvin. That concludes the proponent's testimony. Questions for the delegate or her panel? Senator Sidnor.
Thank you very much. For the sponsor, and just so we're clear for the record, as you noted, last year the Senate passed a version, and this was essentially built on the foundation of the bill that we passed out of our body last year. What is the distinction, or are there any distinctions between what we did last year and the bill that you're talking about today?
This bill, just as last year, took a look at those who were incarcerated around issues, rape, sexual offenses. I do want to say that one of the things that was taken out of the original, and you had originally, we had the cross file, was those who in LWOP, life without the possibility of parole, and they do need to be looked at. But in putting this bill in line with what was done last year, we are particularly looking at those who were not in for life without the possibility of parole, and sex offenders. But there's still, I'm gonna just say, in my head, the understanding that there are those that are not included here, but we need to look at them. So this does not curtail that look, that second look, the process. But like you did last year in the Senate, getting us started, and I will say, even with conversations, I see Senator West light on, conversations with Senator West, being able to formulate this as something that on which we can build, building something here from the juvenile restoration, keeping it going, because we do need to pay attention to how we incarcerate. So I do want to, I'm gonna take this time right now for saying to Senator West, thank you for talking to the advocates early on and moving us in a positive direction, because this needs to happen now. And so I don't know if that really answers your question, Senator Sidnor, but they are very, very much like railroad tracks, parallel. Right. So you came up with the amendments. This, not you, this is the collective you, but this committee came up with the amendments to help move it.
And one of the other distinctions between the bill that I presented earlier and the bill that comes over from the House is a narrowing of who your bill would address. Is 18 to 20, yes. 18 to 24-year-olds, correct?
To 25, exactly. Thank you for pointing that out. Yes, so we are making that continuation because this is still the group that science tells us in terms of the full growth of the brain and their maturity are still what did in Miller, the case to the Supreme Court, call it those emerging adults, understanding that they still were in the process mentally and in terms of maturity, in terms of acts, that they are still in that catchment area. Understanding that the 20 years, actually, some of the states that use, let me go back a bit, some of the states that are, have already created second look bills have fewer years of incarceration, because studies also show that essentially beginning about year 10, you start seeing folks who have been incarcerated, those changes being made. We've taken that extra 10 years, 20 years, watching folks grow, things that most of us can't do for 20 minutes. And in a place that is horrific, that is built on stripping a person, stripping their morality, integrity, ability to confess, if you will, or give itself to, lend itself to wanting to even be better. So we've added that. So that's why we have 20 years.
Thank you very much.
Thank you, Senator West.
Thank you, Mr. Vice Chair. And thank you, Delegate Pester, for bringing this bill, the House cross-file of this bill. As you alluded to earlier, I sort of separated myself from some of my colleagues a couple of years ago when I sponsored the Juvenile Restoration Act, and was pleased when it got passed over the governor's veto. But this bill seems to establish a bit of a dichotomy here What you do is you don't amend the Juvenile Restoration Act, you add another subpart to it. And I'm looking at the two, and they don't really sync real well. For example, the first part, the part we passed several years ago, says to be qualified, a person needs to have been sentenced for the offense before October 1, 2021. And then this bill doesn't include any limitation like that. So we're really setting up a situation where someone who today is sentenced at the age of 16 for an offense, 20 years from now, would not be eligible for the Juvenile Restoration Act treatment because that person was sentenced after October 1st, 2021. So would you be opposed to an amendment to the bill which deleted that requirement that a person have been sentenced before October 1st, 2021 in order to qualify for the Juvenile Restoration Act part of this bill?
Well, a distinction here. This says it's built on it. So we have not, I'm with you, there are some holes there, okay? But we are not looking at the juvenile restoration bill in terms of that date, that 2021. In fact, it says that it's retroactive and that it includes going forward, because what we understand is that because there was a Juvenile Restoration Act does not mean that young people the teenagers up to age 25 aren't still immature and make poor decisions. So this bill is in fact addressing that point, that we want to make sure that we are still looking at going forward. Otherwise, we would have the same bill. And it goes, if we want to make connections, to make a connection with a bill I know that you were a big part of, and that is not just medical, but that 60, that we're looking at folks who going forward, beyond anybody who might be 60 or over at this point, what happens down the road. So we want to be able to keep looking at our system, because if we don't look at our system and look at it into perpetuity, if it doesn't go on, we don't fix the system. All we do is take the people who are in it at this point. So we're not really saying, note that we didn't change that date out of the Restoration Act. It's just a piece of information that is when, that October date of 2021, that's information, that's when that bill, what that bill put in as their
well, I thank you for your answer, and I think our committee can work with this bill to make sure that we come out with a finished product which we all can be pleased with.
Fiddle with that, and we can also have a conversation about some things that people have addressed as late as the end of last week about some holes that they've seen in the other bill, not this one, that they thought they wanted to attach. So we can certainly have that conversation.
Yeah, we still have almost 2 weeks to go. I'm sure that there's a lot of work that we can get done.
I'm sorry, what did you say?
I said we have almost 2 weeks until we have to adjourn, so there's a lot of time between then and now to get things done.
Yes, we do. Let me fix my voice. Yes, we do have that amount of time left. Thank you.
Thank you, Delegate. Thank you, Senator. Further questions for the sponsor or her panel? All right, seeing no questions, we'll let you back to your chamber. Thank you so much for taking the time with us.
All right, thank you. Thank
this
all
afternoon.
of you.
We'll now move to the opposition to the bill. First up, Kurt Wolfgang, and then State's Attorney Schellenberger. You'll go last.
Thank you, Mr. Vice Chair. I am Kurt Wolfgang, former prosecutor, defense attorney, and executive director of the Maryland Crime Victims Resource Center. We have provided you written expert testimony from Leonard Sipes concerning our testimony regarding recidivism. Please read it. What you're being told is fantasy about recidivism rates. More than 50% of those released will commit a new violent crime, and that means 5, for every 10 you release, 5 of your constituents are going to be the victim of a violent crime. Let me introduce your constituents who are here today. If you're here, please stand. Senator McKay, your constituents Tammy Messersmith-Embley, whose father was murdered, Angie Fulton, whose brother was murdered because he's gay, and a constituent who can't be here today, Tristan Shiflett. She was your constituent. She's dead because of the Juvenile Restoration Act released someone who murdered her. Mr. Chair and Vice Chair and Senator Love, meet Terry Darvish, whose son was murdered at his home in Germantown. Senator Charles, Senator Muse, meet Sade Newsom, Kaituta Sikyala, who lost 4 family members, including their sister and 2 toddlers, to mass murders by thugs. Meet Joyce Conyers, whose son Willie was murdered, and the murderer released only 21 years after he shot Willie to death just to be a badass. Meet Dawn and Rick Collins. I think you've met them before, whose son, Lieutenant Richard Collins, was butchered because of the color of his skin. Meet Roberta Roper, who the world owes so much to, and who's around whose neck the legislature has already imposed a millstone of agony because she had to testify at the reconsideration proceeding of the man who raped, tortured, and murdered her daughter in one of the most notorious cases in Maryland history. They're all here to tell you that this is a sad, sorry, bad mistake that will result in the death of many more victims and the agony of the people whose disparate impact should be the impact that you're looking at. That disparate impact is on the victims of the crimes. And I thank you for the time.
Thank you, Mr. Wolfgang. And we thank the families for joining us here today. And as you know, after crossover, we have limited testimony, but that doesn't lessen the impact of your appearance today. And I urge you to reach out directly to your members who will be here today, and many of whom will be happy to meet with you. So our condolences to you and our thanks for your joining us here today. Mr. State's Attorney.
Thank you, Senator. Scott Schellenberger, State's Attorney for Baltimore County, here today in opposition to House Bill 853, second I'll look at. First of all, let me address one of the comments from the public defender who made. He said that my list of 12 or 13 items really don't all account for modifying the sentence. But if you look at number 2, it's called a motion to modify a sentence. Number 4 is a 3-judge panel to reduce or modify the sentence. Number 10 is a writ of actual innocence, which can let you out of jail. Obviously, number 13 is the parole system. We just talked about Senate Bill 181 and Senate Bill 1133, 2 more times, medical parole and geriatric parole, in which the sentence can be reduced and changed. So we're now up to so many more versions that I can't even keep track of the numbers. I think it's important that folks like Ms. Roberta Roper is here today and the Martins who are here today, you've heard from all of them before, to take into account what they have to go through, because every one of these hearings, the victims want to come to court, the victims' families. When you lose a loved one, you feel a real sense of obligation that you want to go to court every time that your loved one's case is going to be heard. And so you're talking about going to these hearings over and over and over again. And so not only do we have all these other things, we look like we're going to add 2 more. And then the question becomes, why do we need 3 hearings? All right, if you're going to do a Second Chance Act and be in front of a judge who wasn't the judge when you got sentenced, why do you need 3 of them at year 23, at year 26, and year 29? You know, maybe you just deserve 1 second chance. Thank you.
Thank you. Are there any questions from the committee members? When I'm temporarily sitting in for the chair, there was a gentleman who testified a little while ago against the bill, giving some data about 50% or some high percentage of reoffenders. I assume he was addressing people that have been let out under geriatric or medical parole. So if there's some data, I didn't see it in my file, and I would hope that he could submit it to me and the rest of the committee. And I also just want to take a personal note myself. I'm about Stephanie Roper's age, and my father rarely spoke to me about anything. Certainly, and I mean that in a positive way. He wasn't an over heavy-handed father. But when that young girl was killed, and I was exactly her age, that was one of the only times my father put me into the office and really spoke to me about the incredible dangers of being a young woman. And it has stayed with me my whole life. So to every person who is here, who has lost a loved one, and the Roper family in particular, just because it is relevant to my life particularly, I think I speak for everyone. We deeply, deeply understand how much pain you're going through and how difficult this all is. So I just wanted to make that personal note. All right. Do you have a question, Senator West?
Actually, I do. Mr. Schellenberger. Mr. Schellenberger, I should note, and I are normally together on legislation. This is one of the few times when we have diverged. So the Juvenile Restoration Act was passed, was it 2021 or 2022? Do you recall?
I believe it was 21, which is why that date was inserted into here.
Yes,
And
I think you're right. That's exactly right. So it's been 4 years since we passed that, and it went into effect, as I recall, that October. So it's been now in effect since October 2021. And I think an earlier witness indicated that the recidivism rate for people who have been released is very low. It's around 3%, I think he said. Are you aware of any person released as a result of the Juvenile Restoration Act who has gone on to commit a serious offense?
Not that I'm aware of at the moment. I'll have to do some more research to find that out.
I would love from some source, having been the sponsor of that bill, I would love from some source to get updated information.
Okay.
About,
Actually, Mr. Wolfgang has some stats about that, so please, may I turn it to him?
Maybe he and I could talk off camera later on. I would love to find out the total list of people who have been released, and if any of them have recidivated, what they have done, which would have called them back or caused them to come back into court in that kind of a situation.
Yes, sir. We did provide it in our written testimony as well.
Okay.
There are 4 incidents. There are 4 incidents. Two of them are under JUVRA that we found so far. The other 2 are under similar reconsideration releases.
Okay.
Under Health General.
I confess, the testimony is extensive.
I know.
I have not had a chance to read your testimony. I will, but maybe you and I can talk offline and talk about those 4 cases.
Yes, sir.
I'm hopeful that the decisions of the courts to let people go, given the standards that we put into Juvenile Restoration Act, which are really tough, that the acts were modest acts, not heinous acts that have now caused the recidivism, but I would love to.
No, sir.
They are heinous acts.
Senator McKay's constituent who was murdered, and I don't, the other one was either a murder or a first-degree arson in which he was trying to kill everyone in the building.
Okay.
But
I would love to get that information from you.
Yes,
so
sir.
let's meet offline and talk about that.
And sir, let me comment about, I know the standards you're talking about from the judge, that you impose on the judge.
He's, quote, no longer a threat to society. That's a pretty tough standard.
The standards do not matter. There are plenty of judges out there who believe what the R Street and some of the other entities who testified believe, and that is that there is no use in keeping anyone imprisoned after 20 years for regardless of what they have done, and that's the standard that they're using to release. In Prince George's County, we have to, they are making up their own reasons to bring cases back and do reconsiderations that are not even allowed under the existing statutes, and they are releasing people at an alarming rate. And the theme is, if you've been in more than 20 years, it's time for you to get out.
Well, I hear what you say. If judges, in fact, are doing that, they need to be subject to discipline by the state judiciary because they're failing to follow the statute, which is their duty and their obligation. When they took an oath at the time they got sworn in, they swore to follow the state law. And if they're not following the state law, they need to be disciplined and perhaps removed from the bench. We can talk about that also offline. Thank you.
Yes, sir. Thank you.
Senator Levy, you have a question?
Thank you, Madam Chair. Mr. Wolfgang, you just made some very serious accusations, and I would ask that you provide to this committee evidence that would substantiate those accusations that you just made against judges in Prince George's County, because I would hope that you would not make those lightly. I'm also going to reiterate what the chair said a moment ago, and you made some comments about 50% of recidivation of those that would be released would recidivate. I would ask you to put into the committee and into the record evidence substantiating that. And to Senator West's question about those who were released under JRA, he asked under JRA, and you said 200 JRA and 2 others. Add to that, under JRA, the total number of who were released under JRA, so we're not looking just at those who recidivated, but the total number that were let out. So please follow, it's not a question, it's please follow up with evidence supporting all of the things that you testified to.
I just want to tell you, ma'am, that we will do that. We actually have appealed one of the, probably more than one, but one of the decisions by the judge in Prince George's County based on the fact that they're fabricating things that are not in the statute in order to release people under reconsiderations that are not available, such as the Health General article in which there is supposed to be a finding by some entity that an individual is amenable to rehabilitation treatment for alcohol or drug abuse. They're getting
Mr. Wolfgang, you're getting way off topic here. I just asked you to provide evidence substantiating the things that you said and the serious accusations that you made.
Yes, ma'am.
Thank you.
And just to clarify also, the time is of the essence, sir. We have 2 weeks left. And I think everybody in this committee wants to work with accurate information. So not only do the chair is telling you to follow up with all of us on the request and make sure you do it as quickly as possible. Given how facile you were and quick you were with giving the data, I assume it would be very easy for you to provide.
The recidivism statistics that we provided in writing, we actually sourced our data as opposed to someone standing here and telling you that the figure is 3 to 4%.
That's what we would appreciate getting from you. Thank you, sir. Thank you.
In addition to that, we actually got a statistician to provide written documentation to you this time. That is the written testimony of Leonard Sipes, who is he actually was for 16 years the spokesperson for the Maryland Department of Public Safety and Correctional Services, and he has given you reliable recidivism data.
Very good. Thank you, sir. Thank you very much. All right, that will conclude the hearing for this bill. I'm going to call out and just see if we have any members who can speak to the remaining House bills. House Bill 963, Montgomery County Delegation. Is there anybody from the delegation? Oh, great. Come on up. Welcome.
Good evening, Chair, Vice Chair, members of the committee. Just for the record, my name is Megan Travers. I'm Legislative Director for Delegate David Moon. Sorry. Okay. Okay. Good evening, Chair, Vice Chair, members of the committee. Just for the record, Megan Travers, Legislative Director for Delegate David Moon. House Bill 963 is a proposal that you all have seen last year in this committee, although it is slightly different in a slightly different posture, but still captures the same intent. This year's iteration permits a local authority to decrease the maximum speed limit on a highway without performing an engineering and traffic investigation. So the speed enforcement provisions that were mentioned last year are not mentioned in this year's bill. Research has shown that the risk of severe fatal injury increases dramatically with higher speeds. County transportation officials already have the tools and expertise needed to make the streets safer. However, the current requirement for study and review creates delays and incurs high fiscal costs, preventing them from efficiently making the roadways safer. We've worked closely with a number of local advocates and officials, including Greater Washington, Montgomery County government, City of Tacoma Park, and WABA, the Washington Area Bicyclists Association. All of them have submitted favorable testimony on this bill. So with that, I think I've got everything. Thank you all for your time and consideration, and just ask for a favorable report on this bill, and just happy to answer any questions.
Thank you for waiting with us on this long day. Any questions for this witness? All right, that'll conclude the hearing on House Bill 963. Wow, I was going to ask if there's anybody in the room for House Bill 988. It's another Montgomery County delegation bill, not in your lane. Let's see. 1125. Well, that's, yeah, I already read that. Did we do this one? Did we do that one? Do we do 1227? All right, how about House Bill, I feel like I'm doing an auction. All right, I want to have a all right, House Bill 1227, Montgomery County School Bus
I was
Bill.
just about to say I can cover.
You can cover,
that
yeah,
one,
we're making progress, great.
Yes, so good afternoon, evening now, just for the record again, Megan Travers, Legislative Director for Delegate David Moon. And I didn't mention this earlier, but apologies that he's not able to be here. But happy to uplift any remaining questions I can answer to him after this hearing. So this committee is no stranger to school bus legislation. You all have done a lot of great work to make sure students are safe when traveling to and from school. Over the summer, the county met with Delegate Moon to discuss the implementation of the local school bus stop law that the committee passed last year. It was House Bill 761. The county just raised some concerns as far as the implementation timeline and requested some more time to come in accordance with provisions of that bill. So HB 1227 just addresses those concerns. So this is a local bill that just extends the effective date to December 2028, whereby Montgomery County will be prohibited from placing a school bus stop on highways with 5 or more undivided lanes that also have 400 citation violations from vehicles traveling in the opposite direction. This prohibition only applies unless there is a school crossing guard or if there is a traffic control device with a red signal that is in place when the students are boarding or exiting the bus. This bill additionally clarifies that the 400 stops referenced are measured within the preceding fiscal year. Initially, the original bill was much broader and had some provisions redirecting fine money from the courts. However, they've been removed in the amended version of the bill. So in its current posture, it's just extending the previously established effective date and providing the fiscal year clarification. So I think that's it, but thank you all again for your time and consideration. I'm happy to answer any questions, and Delegate Moon respectfully requests a favorable report.
Thank you very much. Any questions for this witness? All right, that will conclude the bill hearing on that bill.
Thank you.
And we are left with, ladies and gentlemen, we only have 2 bills left. One is the 988, which is a Montgomery County bill about speeding, and then Delegate Klibinger's bill. So since there is nobody here, we're going to take a little break. I don't know, for 5 minutes, you know, that JPR 5 minutes, and we'll see if we can make any more progress. Otherwise, if I'm in charge, I would say we go home and we'll start tomorrow and we'll add those last 2 bills in, because that seems like a sane thing, but we'll wait 5 minutes. Thank you all.
Barry's a lady.
We're back with the. We're here with the distinguished chairman from the House Judiciary Committee.
Is the distinguished chair here?
Oh, there you
Where's
are.
the distinguished chair? I played to a full house. Look at this.
Make sure you get a proper. House Bill 1125. Welcome.
Good evening, everyone. This is House Bill 1125. It's making an adjustment to the work group on home detention monitoring that would alter the charge of the work group that we passed last year and that hopefully will actually meet. That would be wonderful. It struggled to find people to actually get onto the work group, to get going on the work group, and so hopefully they'll have more than one meeting, because I think it's very important for us to take a closer look to what's going on with electronic home monitoring, and particularly on the private providers of home electronic monitoring. But in any case, it would add a data collection requirement that would include gathering policies and practices when a person violates a condition of home monitoring, asks specific data about the number of people who are placed on home monitoring, disaggregated by race, gender, jurisdiction, the company or agency they're using, and the number of times a person on home monitoring has violated a condition of the monitoring. I think it's important for us to get that information. We passed legislation last year that increased the requirements for these companies, in many cases these companies, to provide information quickly to law enforcement. I would ask that those remain the same. I'm not looking for any amendments on that score where they could potentially get out of their current obligations to do that. But if there's more information you'd like to gather, that would be great.
Excellent. How many firms do, like 3 or 4 firms do this in the state of Maryland, right, or something like that?
I think there are 3 or 4, but there are others that are popping up all the time, yeah. And so it just depends on what part of the state you're in. Some of them are working as contractors for local jurisdictions. You have a lot of different varieties.
Excellent. All right, questions for the chairman? All right, seeing none.
I apologize for keeping you, but I was busy hearing some other people's bills.
I know. We appreciate that. All right, seeing no questions, Senator Fulton. Senator Fulton's got.
Hi, thank you,
Senator
Mr. Chairman.
Fulton, I've been preparing all day for this.
Thank you. That's all I needed to know.
Okay.
Maybe. All right, thank you. With that, that'll conclude the hearing for House Bill 1125. Thank you.
We'll figure it out. I can't do everything. Thank you very much, Mr. Chairman. Thank you very much, committee.
Question. We just passed a whole bunch of paired bills. Senate, House, Senate. Can you spring the Senate ones for yours so you pass them? They're all unanimous.
Hey, so, I found out some interesting data. So Montgomery County, that bill you all have, where he said you all want, there's like 80 miles of this, of this roadway that's, what was it called? Hybrid. The safety corridors is only.
All right, let me just read this. Let me just read this really quickly for the record. So it's House Bill 988. What this does is it authorizes the placement and the use by the Maryland Transportation Authority of speed monitoring systems on Maryland Route 200, which is the inter-county connector in Montgomery County, requiring the district court to remit to the authority any civil penalties collected by the district court resulting from a citation issued using speed monitoring systems operated by the authority, and requiring the State Highway Administration to provide the authority with access to certain systems and contacts. With that, that'll conclude the hearing for House Bill 988. All right, so that'll conclude our hearings for the day. We are on the floor at 10:30 tomorrow. Then we have mostly sponsor-only bill hearings, and then we've got concur, not concur. 10:30 on